I am the owner of a sectional title unit, and the body corporate has approved the building of a guardhouse, 24-hour security right next to my unit, literally sharing a wall. My bedroom is right there, and I'm so concerned about noise disturbance sharing a wall, implications on the value of my property, as who would want to rent a unit with an attached guardhouse to it, never mind also being at the entrance of the complex. Just interestingly enough, Nick, reading that, never mind being at the entrance of the complex, it almost implies like it's now an entrance. But
sure.
maybe not.
Sure.
Then number 3, my privacy. There are new, okay, so the provision is there are numerous other spaces where they could build the structure, still in view of the entrance, but according to them, the location is perfect for the guard to properly see all in and outgoing movement. And they have already started with the building the foundation. I'm so upset. Is there anything I can do to stop this? I've approached them to no avail. Please advise.
Look, it's an interesting question, and there's a couple of different approaches on it. The first aspect that you've got to deal with on this particular question is, obviously you've said here that the body corporate has approved the building of the guardhouse. Now, there are a couple of assumptions that have got to go into that. Obviously, for a body corporate to function and make decisions on how they deal with property, there do have to be obviously votes and resolutions in order to change things or to do things on behalf of the body corporate. Okay, so the first assumption I'm going to have to make in the circumstances is that resolution process was followed correctly. Okay, if it wasn't followed correctly, there wasn't a proper resolution and they weren't properly authorized, then yes, there's absolutely something you can do, because they need to follow the correct process that is set out by the body corporate for making decisions on behalf of the body corporate. But I'm going to assume that was correctly done. The next thing that needs to be dealt with is where the building itself is situated. Now, I know you've obviously indicated it's next to your unit, but sectional schemes are made up of a number of different allocations of property. Obviously, you have private units, and that is the unit that you live in. Okay, then there are exclusive use areas, which are areas within the scheme that are designated as exclusive use to a particular unit. A good example is a balcony or perhaps a garden of a particular unit might be designated an exclusive use area. And then there is common property, which is obviously property around the complex that is shared by everyone in indivisible shares. All right. The body corporate would only be able to deal and do something like this in respect of common property within the particular scheme. It could never happen on an exclusive use area or within someone's private residence. That would obviously affect their ownership rights in the circumstances. But it seems to me, you've indicated this is on the outside of your unit wall, so it's likely that this is a common property situation. If it is, again, depending on whether the resolution was properly passed and it's sitting on a common property area, then this might well be allowed. If either of those is negative, there's absolutely something you can do in the circumstances to stop it going ahead until such time as those things are properly dealt with. As for the things that you've mentioned within your question, noise disturbance, implication on the value of your property, and your privacy. The one problem that we do have with respect to all of those elements is we don't know that those are actually going to be things that eventually come about as a result of the building of this particular building. So, for instance, noise disturbance, we appreciate 100% that you have a concern with regards to whether there will or will not be a noise disturbance, but whether that noise disturbance will actually materialize at a later stage is a different question. And unfortunately, courts don't grant orders on speculation. You must show that there is a right which is being infringed. So If the guardhouse is built and there is a noise disturbance, that's a very different position to, I believe that one might occur in the future. And a court can certainly help you in circumstances where there is a noise disturbance, but they will be reluctant to help you where you assume one might come in the future. They don't work in speculation. Unfortunately, you're going to have to show that is the case. Same thing, unfortunately, with the others. So the value of the property, it's a speculation that your value of your property might go down. You don't know. Infringing on your privacy is unfortunately the same thing. So in respect of those three grounds, I don't think you're going to have grounds to approach a court in order to stop them. And just for interest's sake, while we are talking about it, if you were going to stop them, say you do find out that the resolutions for the building of the particular guardhouse weren't properly resolved, you would approach court on an interdict basis. So you'd ask the court to interdict the body corporate from continuing building the guardhouse until such time as there's a proper resolution or that dispute is sorted out. And that is similarly to our first question of the day, also a application which can be brought on an urgent basis. That's something you can approach court on an extremely urgent basis to stop them from continuing the building until such time as is proper approval for the building of that particular guardhouse in the circumstances.
Yeah, so that's 100% on point, and I suppose that's the difference between the question of legal recourse and proper action, or next steps or action tasks. So a legal recourse, going to court and saying, I am going to suffer prejudice because of noise. But no, there's no evidence. It's so difficult to prove, because why would there be more noise? Is there an anticipation that this again? So we were debating this, just throwing different ideas around. So yes, hypothetically, if there was an alarm attached to the boom that opened, and every time a car drove by, there was this loud noise as the boom opened, different story. But now the reality is going to court. Remember, going to court and making those affirmance. The court isn't about a fishing expedition. So you don't go to court and say, I think they might, but they need to come prove that it won't, because that's not how it works. The onus is on you to look for a court order because you have enough evidence to say this is what's going to happen. So maybe the strategy here is set yourself up to be in a better position. So start addressing correspondence, asking certain questions, but you need to position the question. So you can't just say, is my property going to lose value? Because they're not going to know. The answer is not, they're not going to be able to answer you, and it's going to be speculative. But about noise, you need to be very specific and say, all right, well, I'm willing to consider this, but my concern regarding noise is as follows. Is there going to be conversations right outside my window where people are going to be asking for copies of the driver's license and permission slips? And is there a little intercom that everyone's going to need to click, and that's going to make a loud ringing noise, and is going to dial through a number of another unit somewhere in the complex? And I'm going to be able to hear this tone. I'm going to be able to hear the conversation and the gate opening and the loud noises, when the gate opens. Start putting this to them, because basically all that's going to happen is you're setting yourself up. You're asking them, how do they intend to actually do this? Get the facts. Two things are going to happen. You're going to get enough facts to possibly be able to go to court. We're not saying you will, but maybe there's enough there going, it's literally a meter from my window. It's disruptive. I need 8 hours consecutive sleep, and this is going to wake me up every time that intercom is pressed. Maybe. But best case scenario, you're going to annoy them enough that they're not going to want to build it next to you, because they know that you're going to be that, excuse my language, pain in the ass, that every time something happens, you're going to be complaining and taking them to CSOS as an example, complaining about the noise. And the nice thing with CSOS is you can lay the complaints. Like, cost orders aren't a thing there. So going to court, you lose, you get a cost order. Going to CSOS, lay the complaint. And they're going to realize, sure, do I want this headache? And you might then be able to persuade them to move it somewhere else. So that's a kind of a practical scenario, practical advice. Don't go to court, but set yourself up in case you do. Otherwise, just be very annoying and to convince them to, basically persuade them at the end of the day not to build it at that specific place.
Yeah, or at least raise the concerns with the body corporate, because if they are in I think you said here they've started sort of building, raise these concerns early. Make sure that if there is an intercom or something, can it be moved? Can it be placed in a position that it's not going to actually infringe on your ownership rights? Because as Bruno says, let them know that if they do end up infringing on those rights, you're going to then approach a tribunal in the circumstances to have it remedied. So they
Absolutely.
say,
Yeah, absolutely. And I see over here from the conversation, he says, I have approached them to no avail. So the nice thing is, if they start refusing to respond to you, that's also a ground for complaint. So you can already start complaining, saying they're not responding. Then force a response and then get this evidence and put them in a position where they now need to be very careful on how they do this installation. And you'll find that it might just be easier for them to do it somewhere else, or to engage and come up with a solution.
Yeah, 100%.